Ready, start. In our considered opinion, there seems to be ample evidence to presume legitimacy, and there is absolutely no confusion as to whether the presumption would apply. Full stop. Further, as analyzed in detail above, the balance of interest does not support mandating a DNA test, as it is likely to have a disproportionately adverse impact on the appellant and the respondent's mother. Full stop. As a result, there is no single inverted comma imminent need single inverted comma close for a DNA test. Full stop. In light of the above, it is evident that the High Court erred in holding that the respondent's legitimate interest to know his father outweighs the infringement of the appellant's right to privacy and dignity. Full stop. Since the overlapping nature of paternity and legitimacy have been exhaustively explained in the first issue, we do not deem it necessary to delve into it again. Full stop. In the present scenario, the family court seems to have acted within its powers under section 151 of the CPC, by self-imposing a condition regarding the revival of the maintenance petition. Full stop. Through its order dated 5/2/2010, the family court merely kept the maintenance petition in abeyance, only to be opened depending on the outcome of the civil proceedings. Full stop. This condition was fairly applied, after recognizing that the family court would, incidentally adjudicate on the legitimacy of the respondent while determining maintenance. Full stop. If the family court proceeded with the maintenance petition, it would result in parallel proceedings, both of which, would have involved an examination of the legitimacy of the respondent. Full stop. These parallel proceedings would not have served the interests of justice, but instead, would have further complicated the matter. Full stop. Instead, it was appropriate to place a temporary pause on the maintenance proceedings and to allow the original suit to come to its logical conclusion. Full stop. Further, had there been a finding favoring the respondent in the original suit, the disposal of the maintenance petition would have perhaps become easier, as the respondent would not have to establish why the claim was laid against a third party. Full stop. Nevertheless, in our considered view, this condition was not abhorrent to law, as it was necessary in the interest of justice to avoid multiple proceedings, and it did not cause any prejudice to the rights of the parties. Full stop. As a result, the order dated 5/2/2010 is perfectly valid. Full stop. In any case, considering the fact that the condition imposed was not satisfied, the maintenance petition could not have been revived or reopened. Full stop. As a necessary corollary thereto, we must clarify that the family court erred in reviving the maintenance petition vide its order dated 9/11/2015. Full stop. In pursuance thereto, we find it imperative to examine the issue pertaining to the revival of the maintenance petition through the lens of the principle of res judicata. Full stop. Though such a contention has not been raised by the parties, it is nonetheless essential, as the reopening of the maintenance petition could very well fall foul of this fundamental doctrine of law. Full stop. The principle of res judicata is a salutary and pragmatic edict to reinforce the doctrine of finality. Full stop.